Some Connecticut couples opt for mediation as the process to resolve their divorce. What that means is that they decide to retain a neutral mediator. That person is typically an experienced divorce lawyer who's also trained in mediation, to guide the conversation that they have around the things they need to decide in their divorce. So things like how parenting would work, child support, alimony, property division. So they choose mediation as the way to resolve those issues. A mediator doesn't make decisions for them. The mediator helps them reach decisions on their own. And then after the mediation is over, they would bring what they agreed to attorneys to make sure that it meets all of the legal requirements and is going to be something that a judge in Connecticut will accept. And it gets filed in front of the court so that the court can review it and order their marriage dissolved, order them essentially unmarried. So mediation is basically a way to choose to resolve your divorce before you go to court so that everything has been agreed to by the time you go to court. Some of the advantages of mediation are that both people are deciding to stay out of court as much as possible. They're deciding to retain someone to help them reach decisions as opposed to deciding that a judge is going to make decisions for them. So people often wonder whether every divorce in Connecticut has a mediation component. It's a very, very reasonable question because in many states, every divorce, even litigated divorces, have a stage in them where the parties are required to go through a mediation process. It works a little differently in Connecticut. So in most cases in Connecticut, when people talk about mediating their divorce, that means that the two spouses have decided together, they've agreed to go to a mediator to help them reach decisions on the things that you need to decide in a divorce, like property, alimony, how parenting will work if they have children, things like that. So mediation in Connecticut usually refers to that process. That said, a lot of people use mediation if they get far along in a litigated divorce and they haven't reached an agreement on all of the issues. So in that case, what would happen is they would file a litigated divorce and things would proceed. The lawyers would negotiate. There would probably be some hearings on the way as they tried to resolve certain issues. And then at a certain point, what might happen is the lawyers, in consultation with their clients, suggest the idea of going to a mediator mid-litigated divorce to try and resolve as many things as they can on the side without having to go forward and asking a judge to decide. In that case, very often the mediator that they use in the middle of a litigated divorce tends to be a retired judge. So you're getting the take of someone who used to be sitting on the divorce and family court bench in Connecticut to help you resolve the outstanding issues. So there are sort of two major ways to mediate in Connecticut. The first, and by far the most common, is to retain a private mediator who's commonly an experienced divorce lawyer who's also trained in mediation to help you reach decisions on your own in your divorce. That's the most common version of mediation. The second type of mediation in Connecticut, which is less common, is in a fully litigated divorce where the parties opt to do mediation right at the end, generally as they're running up to trial, to see if they can get some help from a mediator to help them resolve things on their own and avoid the need to go forward with a trial. When you and your spouse or partner opt to use mediation to try and resolve the issues in your court, one of the things you might be wondering is, how do we exchange information? How does the mediation take care of that part of the process as opposed to a litigated divorce where there would probably be a much more formal discovery process? So the answer is in a mediation, you wouldn't see things like depositions. You probably wouldn't see things like interrogatories, but you need to be open in a mediation to the full and open exchange of information. It will be less formal. You probably won't be in a room with a court reporter or things like that, but the parties need to openly exchange documents so that they can both make sure that they are making the best decisions. The mediator that they're working with will also want to see those documents so that she can give recommendations about how they might want to structure the divorce. The mediator will also need that information so that she can properly ensure that the parties are taking into account all of the things that they need to when they make their decisions. So, for example, a mediator doesn't give the two people in the mediation legal advice. Even though they're an attorney, they don't represent either of the spouses. They sit in the middle of as a neutral person to help the spouses decide. That said, they want to make sure that the spouses make decisions on everything that they have to make decisions on. So, for example, the spouses need to exchange information about their assets and liabilities and things like that so that the mediator can help them make sure that they're addressing all of the things that need to be addressed in their final divorce settlement agreement. If you and your spouse opt to use mediation rather than going forward with a litigated divorce, here are a few of the things that you should know about how that process unfolds. First, you're probably going to do all of your meetings with your mediator and do all of the homework that your mediator suggests so that you can reach agreements, hopefully, on everything in your divorce before we even file your divorce. In addition to the mediator, what the spouses do is hire an attorney for a limited role. We tend to call it mediation review counsel. And that's someone that you can meet with and make sure that the agreements that you're reaching in mediation are in your best interest and will work for you. Here at Freed Marcroft, we sit in both roles for different clients. Sometimes we're the mediator that's helping two people reach agreements, and sometimes we're the mediation review counsel who helps one client analyze what's happening in the mediation and make the decisions that are best for that client and their future. So the mediation process tends to unfold something like this. You don't file the divorce first. What you first do is you and your spouse decide to mediate. You retain a neutral mediator to help you. You each get your own mediation review counsel so that you have someone who represents you, who you can bounce ideas off of, who can give you legal advice. You get that all squared away. You exchange documents and you engage in a series of meetings with the mediator. Your review counsel doesn't tend to go to those. It's often just you, your spouse, and the mediator. And then what you do is you come up with an agreement that you've reviewed with your review counsel and everybody's comfortable with it. You review it and you sign it. Then it's time to file it with the court. Once you filed the agreement you reached in mediation with the court, the judge reviews it, makes sure that the judge is comfortable with what you agreed to in the mediation, make sure it corresponds with the relevant rules and regulations in Connecticut, and assuming all that's true, the judge will order you divorced. In most cases, you do not have to physically go to court for a final divorce hearing when the judge orders your divorce as final. In some cases, you have to, so it's important to know that you might have to go to court one time to answer some questions for the judge, and then your divorce will be granted. But for a lot of people, they don't even end up going to court, and their divorce is finalized, what's called on the paper. So in other words, the judge reviews it and then orders it without you being physically present in court. One of the terms that people use when they're talking about divorce is litigated divorce. Another term they use is traditional divorce. But I'm not sure it's exactly clear what those two things mean. So let's take a little bit of time and go through what people mean when they say litigated divorce or traditional divorce. So here's what that means. Any divorce has to go through the court. That's a really important thing to know. So maybe you've heard of divorce mediation. Maybe you've heard of collaborative divorce. Those are processes that happen outside of court, where you reach agreements outside of court. But even in mediation and collaborative divorce, ultimately, a Connecticut state judge needs to review the agreement you came up with and order your divorce. So there's always some component of court involvement in every divorce in Connecticut. That said, sometimes it's a very limited role, like we talked about, reviewing an agreement that you reached. In other cases, it's a litigated divorce. What that means is you don't opt into an alternative process like mediation or collaborative divorce. The vast majority of divorces in Connecticut are still litigated divorces. Here's how that looks. You file a complaint and summons to initiate your divorce in the state of Connecticut. And then things start to happen. You start to maybe negotiate to reach an agreement. That happens all the time in litigated divorces. You might have a hearing in front of a judge to resolve an issue that comes up. The divorce proceeds in court when it's a litigated divorce or a traditional divorce, but just because it's proceeding in court doesn't mean that it's going to be high conflict. And it doesn't mean that you won't ultimately reach an agreement and resolve all of the issues in your divorce. It's important to know that most divorces are litigated and to also know that most litigated divorces resolve outside of court by way of an agreement. We spend a lot of time talking about the pros of alternative processes like mediation or collaborative divorce. And that's because if both people opt into an alternative process where they're agreeing to resolve their issues outside of court and they're getting the support of professionals that will help them accomplish that, that's generally speaking a good thing. It keeps conflict reduced and it sets clients up to have a supported divorce that resolves outside of court. But that doesn't mean that there aren't advantages to litigation, which is the default process in Connecticut. There are. Sometimes one spouse would like a divorce and the other spouse wouldn't like a divorce. In cases like that, sometimes the spouse who isn't really on board with the divorce tends to drag their feet. They might not engage in the process. They might delay. And in cases like that, filing for a divorce involving the court helps the spouse that isn't as positive about the divorce to understand that this is really happening, that their spouse is serious, and it can really create a situation where they engage. Similarly, one of the advantages of having the court involved is that there are court deadlines that mean that everyone has to keep the divorce moving forward. If you and your spouse are working well together and you understand that you want to get through the process as effectively and efficiently as possible, and you do your homework in between mediation sessions and you show up for them and schedule them, then mediation is a good option for you. However, if one spouse isn't engaging, isn't providing documentation, and things like that, involving the court might help them move things along. It might actually result in a hearing where a judge makes a decision, and that way you've moved things forward that way. But it can also, just the very fact that there is a court date coming can tend to encourage settlement discussions, and you might wind up reaching a negotiated resolution that way. When we are working with clients who are trying to figure out what the best divorce process will be for them, I think that one of the things I see a little bit too often is that we approach these things in the wrong order when we're heading into a divorce. A lot of times, the spouse initiating the divorce really wants to make it a fair, peaceful process that honors the relationship and the marriage that they had, which is a wonderful intention. But what it can do is cause them to choose a process without really thinking out all of the pros and cons. So, some of my best advice is rather than focus on what process you're going to use to divorce, the first most important thing is to focus on what your goals are for not only the divorce itself, but your life after the divorce. When you meet with an experienced divorce firm like the lawyers at Freed Marcroft, we have seen collaborative divorces, mediated divorces, litigated divorces, both high and low conflict divorces. We've seen a lot of divorces and helped a lot of people through them. And what that means is if you give us the opportunity to really get to know you, to really understand what your goals are for your future, and to tell us a little bit about your spouse and how they're reacting and feeling about the divorce, we can give you really solid advice on how we'd recommend you proceed. And remember, in order to do anything other than litigated divorce, both people need to agree. Both spouses need to affirmatively opt in to mediation or opt into collaborative divorce. If you don't both agree to one of those alternatives, then that means you have a litigated divorce, and that is just fine. If you ever have any questions about which process might work best for you and your family, please reach out. We'd be happy to have a discussion with you.